Okay, let's do it. Everyone, I'd like to introduce Matt Cohen. He's an attorney and advocate for um, kids with disabilities. So I'm going to give you the floor, Matt. We will be having questions after the presentation, so please hold off so Matt can get through the presentation. It's all
Great.
yours, Matt. Thank you.
Thank you. And I appreciate the chance to talk to everybody and appreciate that Merlin and Bluebird and IS Landing support these sorts of trainings. So that's a very important thing that you're doing in addition to the work with individual kids. The experience that I've had started in the late 1970s, shortly after the federal special education law was passed. And I've been representing kids with disabilities in my law firm in one incarnation or another ever since. And this is a law that we've spent a long time fighting to improve and to protect. We are now in an unusual position, which I'll talk about in a couple of minutes, in that the law is under attack. And I would encourage all of the audience to pay attention to what's happening in Washington and to let your legislators know that you support the right of kids with disabilities to receive special education services, that there be adequate funding for special education services, and the rights and safeguards that I'm going to be talking about a bit this evening are protected. The law that passed the right to a special education services was initially called the Education for All Handicapped Children Act and is now called the Individuals with Disabilities Education Act. And it had some basic principles. Number one, that every child with a disability was entitled to receive special education services to meet their needs, and that the school districts had to affirmatively identify all kids who might have disabilities and, with the consent of their parents, evaluate them to determine if they qualified for special education, that the parents were entitled to be participants, and even terminology that's used is equal participants, though that's only true in some respects, but the parents are entitled to participate in the process, learn about their child's needs, share their concerns about their child, and provide consent for their child to receive special ed services. That the child's program is supposed to be based on an evaluation that identifies what their needs are. And then whatever those needs are, once it's been determined that the child qualifies for an IEP, the school district is required to develop an IEP, an individualized educational program, which is intended to address the needs that have been identified and to address it through a plan that contains goals and objectives that are developed in conjunction with the parents and that require that the progress of the child be monitored and that progress be shared with the family and subject to at least annual review and updating. And then the additional thing that the law required that's very powerful is the law says that if there's a disagreement between the parents and the school, the parents have the right to request something called mediation, which is a process that allows the parties to come together, and a neutral mediator tries to help the parties to communicate and sort out what can be done to find a compromise that meets the parents' concerns that the school also feels is workable. And then equally importantly, if the parties are not able to reach an agreement in that way, the law provides parents with the right to request something called an impartial due process hearing that leads to the appointment of a neutral hearing officer or judge by the state of Illinois, and then leads to the convening of a hearing, which is really very much like a trial with sworn testimony, and the testimony is under oath. There's a right to direct and cross-examination, and then the hearing officer has the ability to say whether the parents or school is correct and to order whatever needs to be done for that child based on who they feel is correct in the case. So many very basic rights. And interestingly, some of you may have heard that the U.S. Supreme Court is heard a case today about whether people who are kids who are born in the United States, regardless of who their parents are and whether their parents are citizens, are entitled to become citizens themselves under a part of the 14th Amendment of the Constitution that's called the Birthright Clause. And I mention that because a lot of things that are happening in Washington right now have to do with the administration, President Trump saying, we're going to change things and do things differently, regardless of whether the statutes say that, regardless of whether the regulations say that. And part of what the case that was before the Supreme Court today was designed to address is whether the trial courts, the federal courts, have the power to say that what the federal administration is doing is incorrect and to stop them from doing things that are illegal. And that's very important for a whole variety of rights that we have and for what the federal government is doing or not doing that perhaps is not what it should be doing, but it may have impacts in the next several years in relation to special education also. So this is something where, as people may be aware, there's an effort by the administration to do away with the U.S. Department of Education, to do away with some of the ways that the federal government has historically enforced the special education laws, including by firing many of the staff and diluting the enforcement mechanisms, and we don't know yet, but may result in a dramatic change in how special education is funded that could result in a substantial reduction or dilution in the funding and in the requirements that go hand in hand with the funding. But with all of that said, so we're playing defense right now in terms of what the rights are of kids with disabilities. But what I want to do, and I'm going to talk about labels in just a minute, but I want to talk first about the wisdom of the law itself, because the focus on the individualized educational program is that the school needs to figure out what are the child's needs. And that's, by the way, with the input of the parents, and even for older children, the input of the kids, what the kids' needs are based on the official label that they're given and the impact of that label or diagnosis on their functioning, and even on related issues that might not be directly related to their disability or diagnosis. They're supposed to develop specific information that tells us where they are today in relation to their functioning, what the gaps or deficits are, then to develop goals and objectives that are intended to help to address and remediate those gaps. And then those have to be reviewed on a quarterly basis or more often, and then reviewed in an IEP meeting at least annually. And further evaluation has to be done at least every 3 years to make sure that the individualized educational program continues to be relevant to the child and is meeting the child's needs. They may be doing better than expected, and so there may be less need for services, or they may be struggling and making less progress than expected. And the IEP process is supposed to allow the school staff and the parents to recognize that the child is struggling and figure out what needs to be done to address that. Now, in order to qualify for special ed, you have to meet the criteria for one of the 13 categories of disability that the federal law provides. It includes things like intellectual disability, emotional disturbance, learning disability, hearing impairment, vision impairment, other health impaired, which covers things like ADHD and Tourette syndrome. And notably, because I think a lot of the families that participate at Merlin and Nias Landing and Bluebird are younger. One of the disability categories is called developmental delay, which is kind of an umbrella that covers when we don't know for sure what disability label to apply to the child because they're so young. So we recognize that they have a disability, but we're going to wait a little bit to say what that final disability label is going to be. But it's important to know that the developmental disability label is only usable between the age of 3 and 9 for a child who's recognized as being entitled to an IEP. And then after that, they have to be given one of the other labels in order to continue. Officially, labels are supposed to be just an entry point into special ed. They're not supposed to define what a child is eligible for. But as many of you whose children have already gotten IEPs probably experience, in fact, what the label is often influences what the services are that the child is recommended for, or even what the school says that the child may qualify for. And so it's very important to make sure that your child is getting the right label. And also, we're a society of labels, whether it's red state, blue state, or Cubs fan or Sox fan or whatever else, labels tell us something about a person, but they're only a generalization about the person, and they can be very stigmatizing. So it's important to be careful about what the labels are that are being assigned. And frankly, some of the labels can be more stigmatizing than others. So you want to be very thoughtful about making sure that your child is getting the right label. It also leads to assumptions. For example, one of the labels is autism, and the label of autism covers kids from kids who have severe intellectual delays and are nonverbal and may even be engaging in self-injurious behavior, to kids who are what we call high functioning and may have significant social deficits, but no intellectual delays, and are able to use oral communication or written communication quite effectively. So the label itself is a very, very broad catch-all for a series of symptoms that may or may not capture the particular child and what their strengths and needs are. It's also important to say when kids are being given labels that the IEP process is supposed to incorporate a statement of the child's strengths, including the parent identifying what the strengths are. And it's very important to make sure that the school is appropriately recognizing the things that the child has as strengths. And strengths could be strengths in comparison to everybody. The child has a very high IQ or a very high ability to do sports or music. Strengths could be relative strengths, meaning that the child may be delayed across all areas compared to their age peers, but nonetheless, they have a number of strengths in terms of where their greater weaknesses are and their greater abilities are. You always want to make sure that the school is trying to build on strengths as well as to address weaknesses. The special ed system is supposed to be individualized rather than driven by label, but the sad reality is that a lot of tracking does occur, and you want to make sure that the label that you have selected for your child gets your child the most access to services with the least stigma or segregation. So yes, you want to make sure that they get all the instruction and related services that they need, but without them being either given a label that's very stigmatizing or leading to them being removed from regular education and access to typical peers as much as possible. In the special ed system, the child, once their label is provided and their needs are identified, they're entitled to have the school develop with parent input an individualized educational program. And historically, going back to when the law was passed in the late 70s and was being first understood in the early 80s, there was a big dispute about what was the child entitled to. And the important standard that parents need to constantly be thinking about and aware of is that kids with disabilities are entitled to a free, appropriate public education in the least restrictive environment. The question, the $64 million question, is what's appropriate and what's least restrictive for that child? And in the early days of special ed, and really in many ways until today, the courts and school districts frequently used a reference to a Supreme Court case called the Rowley case, which said that the school districts are required to provide an appropriate education, but that the word appropriate means that the child is making some progress without much definition of what some progress meant. And many school districts interpreted some progress to mean any progress. As long as they could measure that there was a little progress, they were doing their job. As lawyers like me and advocates would argue, that some progress meant meaningful progress. And so there were lots of fights about what the word appropriate meant. And just a couple of years ago, the Supreme Court said, considered the issue of whether some benefit or making progress was enough. And in a case that some of you may have heard of, called the Andrew F. versus Douglas County School District case, the Supreme Court said that the school district is required to provide an ambitious program that is designed to allow the child to achieve challenging goals. Now, I wish that I was the one who got to define what that means for all of the kids around the country. In my mind, challenging by definition would mean that you're providing goals that are achievable for the child, but out the outer edge of what's achievable. In other words, they're not easy or guaranteed, but they're intended to challenge them, meaning that they have to be somewhat difficult for them in order to be able to make as much progress as possible. And the Supreme Court also said that it's supposed to be based on individual circumstances. And as I said, it's supposed to be an ambitious program, which again, if you just take this dictionary definition, would be a program that actually provides something substantial for the child. What does that mean? Historically, school districts would describe the Rowley standard as being that you're entitled to a Chevy versus a Cadillac. You're not entitled to a Cadillac. In my mind, the appropriate understanding of the appropriateness standard is that a child is entitled to a car that runs, not a lemon that won't run. It needs to be a car that will get you from your starting place to the place that you want to go. So we don't really care in my mind whether it's a Chevy or a Cadillac, and perhaps you don't need a Cadillac, but you do need a car that works, that's going to allow the child to make meaningful progress. And so that's what you need to be advocating for. Use the word necessary for a child, not what's best, but what they need in order to make progress. As I mentioned earlier, the law also gives parents a lot of rights. You have the right to give informed consent to your child being placed in special ed. And by the way, you also have the right to remove consent if you decide your child should no longer be in special ed. And the school is required to honor that. That may or may not be a good idea, but in any event, you have that right. You have the right to participate in all formal meetings that relate to eligibility of whether your child has a disability and what it is. And you have a right to participate in all IEP meetings about the child. You have the right to receive regular progress reports on how the child is doing and meeting their goals. You have the right to receive notice about any consideration to change the child's position, program, placement, or services, and to be given at least 10 days to object to that by requesting mediation or due process before any change is implemented. And you have the right to be sure that the school's educators who know your child and know about your child's disability and the testing that's being used are present at the meeting and able to discuss your child in a way that is informed and helpful to you. They also have to have the ability to actually make decisions at the meeting. The basic components of the IEP include documentation of what the evaluation results are from the eligibility testing or the 3-year retesting. They have the requirement that it identifies what the child's disabilities are. And then in the first few pages of the IEP, you'll typically see specific questions about whether the child has a need for assistive technology, whether they may have behavior issues that may require a behavior intervention plan, whether they may have a hearing or vision impairment that requires special accommodations for those needs. And then the IEP is supposed to describe the child's present levels of academic and functional performance. Academic performance is basically how do they do on academic tasks that are related to the curriculum. Functional performance has to do with how do they actually manage throughout the day? Are they able to get to class on time? Are they able to understand the assignments? Are they able to socialize with their peers appropriately and make friends and figure out what they want to eat at lunch and on and on? The IEP is supposed to include a statement of the child's strengths and whatever the parent's concerns are. And the parent concern section is an important place where you should try to be very specific about what the things are that you're concerned about for your child at that time. The IEP is also supposed to have accommodations and modifications that are things that are important for your child in order to be able to access and function at school. They have to spell out what the assessments will be and whether they'll be modified and what accommodations the child would be entitled to. When your child's in high school, you want to make sure that the test accommodations that you think they need are spelled out, because that may also affect the accommodations that they're entitled to when they take the SAT and ACT and beyond. And then it's supposed to specifically spell out what the educational services and placements are going to be for the child. And actually, it's even supposed to spell out what options were considered for the child before the team, including the parent, makes a final decision about what's appropriate. Additional special components when a child is suspected of having a learning disability or autism, the law requires that there be specific discussions at the IEP meeting about the considerations that are the basis to decide if the child has autism or a learning disability and what types of adjustments need to be made to accommodate the autistic symptoms or the learning disability. If a child is 14 and a half, the school has to provide a special discussion about what the transition needs are of the child and develop something called a transition plan. And if a child has behavioral concerns, the school district should be developing something called a functional behavioral analysis and a behavior intervention
Mama,
plan
of
to
the
address the child's needs. Is someone talking? Okay. If the child gets into behavioral trouble and there's consideration of being suspended for 10 days or more, being expelled, then there's a special IEP process for considering whether the child's behavior was a result of their disability. And if the answer to that was it was a result of their disability, then there are all sorts of rules that come into play, and the child can't be suspended or expelled for more than 10 days. And instead, they have to look at what do they need to do to try to help the child to make more progress. Examples of when the school violates procedures, and parents should be familiar with their procedural rights, but also very concerned about the content of the IEP. If the school convenes an IEP meeting without telling the parents about it, or scheduling the meeting when the parents are unable to attend without having tried to work out a time that works for everybody in advance, that would be a very serious violation of the parents' rights. If you go to the IEP meeting and the staff has already decided what should be in the IEP and what the child's placement should be, that would be a serious violation. If you go to an IEP meeting and the staff refuses to allow the parent to talk or to ask questions, again, that would be serious. Or if the IEP is changed without an IEP meeting, without the parent's consent. All of these things would be indications that the school is denying the parent their right to full participation in the process, and in some instances that they're predetermining the outcome of the IEP. When goals are being developed, and parents should think about what are their goals for the child and come to the IEP meetings prepared to talk about it, but always seek what are called SMART goals: specific, measurable, achievable, relevant, and time specific. Specific meaning that you're trying to address a very specific deficit with a specific skill, like I have a problem with decoding words, and so we're going to have a goal that I'm going to be able to decode words I'm in fourth grade, I'm going to be able to do it after a year at a 3.5 grade level. So I've gone from 2.5 to 3.5. I'm making progress. They should be measurable. So if my problem is decoding, there should be an identification of what my level of decoding disability was at the start of the year, and then a mechanism to measure or figure out how my skills are developing in terms of decoding. It has to be achievable. They should set a goal that is not so crazy in la-la land that there's no way that the child can accomplish it, but it should be challenging. And so that's a balancing act. And sometimes that's hard to figure out, but you want to make sure that your child's not being set up to fail. They need to be relevant. If a child has a problem with stability, having them stand on one foot might be a step towards having overall postural stability. But if you spend years and years practicing standing on one foot, and you never have the child practicing how they're able to go up and down stairs, it's not relevant to their ultimate ability to go up and down stairs. You want to make sure that whatever the goal is will actually help them to accomplish a skill that's needed for them and that's relevant to their ability to be more independent. And it has to be time specific. What's the time period in which we expect the child to be able to make the progress that we're seeking? And that should be over the course of the year, because you write goals that are reviewable for over a year period with objectives that are typically meant to be accomplished in quarterly increments over the course of the year. Goal writing is both a very technical process, and it's a very thoughtful process. And you should think about writing goals in all areas of significant need, but you also want to make sure that you don't overwhelm the child and the staff by writing so many goals that nobody can keep track of them, and there's not enough time in the class hour or in the school day to accomplish them. I once had a case where the school district and the parent wrote 92 goals for the child. It was just impossible for anybody to keep track of all of those goals. And as a result, many things were ignored, forgotten about, or weren't addressed that maybe should have been, but because you want to balance addressing significant needs with not overwhelming everybody, you also need to think about setting priorities and figuring out what are the goals that are the most important. You want the goals to be relevant. You want them to address all the problems and not address problems that are not present. So, for example, if your child is not interested in physics and they have significant problems with mathematics and they have significant problems with understanding concepts, it may not be relevant to have them having to learn physics and developing skills in physics. It may be more relevant for them to have goals that are titrated to their need. And on the other hand, if you have a child who's very bright and may be able to go to college, it doesn't make sense for them to be practicing basic math computation at the single or double digit level for years and years on end. You want to be strategic. What are you trying to achieve for the child in terms of their progress? What are the things that are the key areas where they struggle that may be impediments for them being able to move towards greater independence? And by the way, I should say that the ultimate goal of special ed is to promote the ability of each child to be as independent as possible when they graduate. That doesn't mean that they're going to be cured of their disabilities, but that they're going to be able to function as much on their own as possible, given the nature of their disabilities. Again, you want to make sure that the goals are relevant, that there's a starting point that is realistic and accurate about their needs, and then that the goals and objectives are written in a way to allow you to see the progress in relation to what the starting point was. So, for example, if the starting point is that the child will currently reads at has 40 words vocabulary, and then the goal is to build vocabulary at the third grade level, but it doesn't provide an actual number of words that they're going to add, then the goal doesn't tie in to the baseline. And so you want to make sure that the measurement for the goal and objectives aligns with the baseline. You also want to decide parents should come prepared to talk about the IEP and the goals at the IEP meeting, but ultimately it's also the expert's job, the school staff's job, to be ready to discuss and propose goals and to be able to provide a justification for why the particular goals make sense. And then sometimes it's important to think about what is the placement that you're interested in and to make sure that the goals track with the placement. So if, for example, you say that you want your child in an educational program with typical peers, then you might want to write a goal that says, given the opportunity for interaction with typical peers, Matt will be able to initiate a conversation, maintain appropriate social behavior, read stories, tell a story, etc. And on the other hand, you don't want to write a goal that says Matt will be involved in a specialized curriculum that will require him to be receiving one-to-one instruction 6 hours a day, because one-to-one instruction 6 hours a day is contradictory to having an opportunity to interact with peers. And on the other hand, if you think that interacting with peers is not such a high priority and you really think your child needs a lot of special attention, then you want to write the goals in a way that builds in the type of special intention that you're interested in. Some things that are often forgotten, but there's some very specific rules in the law that say that the school district is supposed to have an IEP in place and ready to go at the start of every school year. They're required to make sure that the IEP is specific in terms of the number of minutes that the child will receive of each service. And that's supposed to not be a range of minutes, but actually a specific number. Schools sometimes play games where they'll say, in some circumstances, the child's entitled to X number of minutes of services a day or a week or a month. But for example, if a school says that the child's entitled to 100 minutes of social work services a month, is that a February month of 4 weeks, or is that a May month of 31 days? And how does that impact where those 100 minutes are going to be provided? So you want to make sure that it's spelling out how the services are going to be provided. You want to spell out whether the services are individual or group, whether they're going to be provided in the regular ed class or in a special ed class. And you want to be sure to spell out that anything you feel the child needs, it's described as what will be provided, not at discretion of the teacher or even at the request of the student. One of the things that's often written into an IEP, for example, is that the student will raise their hand and ask for help when needed, or the student will ask to be given the test in a quiet setting when needed. Well, a whole lot of kids are embarrassed about asking for help, and that might be a goal for them to work on it. But if they need to be given the extra help and or they need to be tested in a quiet room, until they've developed the skill to ask for that themselves, that shouldn't be discretionary for either the teacher or the kid. That ought to be mandatory. So you ought to write those things not based on discretion, but based on things that must be provided. Accommodations are things that the school provides for the child that make it easier for them to make progress in the curriculum. So an accommodation might be extra time on a test. An accommodation might be that they're able to read the social studies textbook with a book on tape rather than having to read it with their eyes. An accommodation might be that if they're distractible, they might be seated at the front of the class so that the teacher can maintain more active engagement with them and they can be more focused on the teacher. So those are things that the adults are supposed to do to make it easier for the child to function. Oftentimes, the accommodations are also written as needed. And in my experience, sometimes when it's written as needed, it actually translates to that the child will not get the accommodation because the teacher never identifies it as needed. So if you feel it's really needed, don't have it be written as needed, have it be written as shall be provided. The other thing that's important to recognize is that accommodations aren't always good for the kid. First of all, as people probably aware, the state of Illinois and school districts administer lots of tests that are given to everybody. So there's a lot of discussion about what accommodations are going to be done on the MAP testing or on the NWA testing or on the other types of testing that are district or school wide. And frankly, those accommodations are generally benefiting the school in terms of looking like their student population is performing better. They don't necessarily have any benefit for the child themselves. And so you need to be thoughtful about whether those accommodations are actually useful or not. But if it's a test that will actually have an impact on your child's placement, on your child's ability to do their lessons, on their grades, then of course you want to make sure that the accommodations are provided. The other thing that's important to recognize is that accommodations don't teach. Accommodations only make it easier for the child to manage in the classroom and with the assignments that they're given. So for example, if there's an accommodation that's written that the teacher will check the child's assignment book for accuracy, that may help the child to have a more accurate assignment book, but it doesn't teach the child how to listen and get down what the assignment is so they can learn that they can do that skill for themselves. So you might want to not only have an accommodation for assignments, you might also want to have a goal that says the student will record assignments accurately up to 80% or 90% or whatever. And that way there has to be an instructional component that actually helps the student to learn. Another example would be the child may use a word processor for essays. That's great. But if the child doesn't know how to type, then using the word processor isn't going to be at all useful. So you need to make sure there's a goal that says the child will learn how to keyboard at least X number of words per minute and with Y accuracy in order to make sure that they're able to use that accommodation successfully. Some kids have behavioral concerns, and parents need to recognize that, and educators need to recognize that's oftentimes a function either of the child's disability itself or of the child's sometimes becoming frustrated just because they have challenges that cause them to feel that they're different than the other kids in class, and they feel self-conscious about it. They can't listen, they can't understand the directions or whatever. And at the same time, you want to make sure that the schools are developing an understanding of why kids have the behavior issue and to build what I call a behavioral umbrella to protect the student. So behavior intervention is supposed to help the child to behave and function more successfully, but that emphasis on positive is very different than how it sometimes plays out, where the school actually is focused much more on negatives. If the child is in really serious trouble, they may be getting considered for suspension or expulsion. And then, as I mentioned at the beginning, there may need to be something called a manifestation determination meeting to see if the child's behavior is a result of their disability. And if it is a result of their disability, they're supposed to figure out what the school can do to help the child to develop the skills so that the behavior won't be repeated. Examples of that could be that the child simply doesn't have the cognitive ability to understand the school rules. Maybe the child has a processing delay or central auditory processing disorder that makes it very difficult for them to understand directions, especially in a loud or chaotic environment. Maybe they have a problem with sensory regulation that makes it highly reactive to unexpected touch or loud noises. The student may have difficulty controlling impulsivity that makes it more likely that they'll violate rules or respond to provocative peers. So you need to try to understand what's happening with the child and the ways that their disability may be contributing to their behavior, and not just their behavior, but interfering with their ability to learn. Okay, and then if the child is not making progress, and it's important for you to keep track of how the child is doing from what the school is reporting, I encourage parents to go in and observe their child at least on a couple of times a year basis. Parents have a legal right to go and observe, not forever, 8 hours every day for a week or anything like that, but the school can set limits on how much you observe and under what circumstances or at what time of day, but they can't prevent you from observing altogether. You should definitely try to make sure that you're getting advanced copies of the child's IEP before IEP meetings so you're not surprised by what they're reporting in terms of how your child is doing. It's not a bad idea. You have a right to review your child's student records, and you can always ask to go in and see the records. And particularly because there are changes happening in Washington that may lead to cutbacks in both rights, funding, and services, parents are well served to be especially conscious of keeping track of how their child is doing so that they can be more effectively advocating if the school suddenly says that they're changing the child's program and there's no good explanation of why that's happening. So very important for you to keep track of how your child is doing and be able to assess whether they're making adequate progress or even that they're making more progress than the school is recognizing and maybe they should be further along. Types of data that we like to keep track of include diagnoses and labels, both clinical and educational, test scores, grades, teacher comments on report cards can be very useful, attendance records and timeliness, things that are identified as needs by the school, present levels of performance, growth change in the goal statements. For example, is the goal getting progressively more challenging from year to year, or are they still staying with the same goal at the same grade level year after year? Are the service minutes increasing or decreasing? What's the frequency of behavior and what's the frequency of detentions and suspensions? And then another rule that I'd strongly encourage you to follow is keep all emails and a log of all communication with the school staff so that if there's ever any issue or concern, you've got a record of what they said to you and what you said to them so that you can bring that up later on. Overall, some basic principles. Know your child and follow your gut. If things don't seem to be working, check out why it's not working. Promote collaboration and trust, but keep track and don't take for granted that you're being given the full picture of what's happening. Prioritize the things that are most important to your child's success. And I would say don't sweat the small stuff. IEPs are complex documents. It's common that errors are made. Sometimes they're very big errors that are very problematic. Sometimes they're very minor errors. Don't worry so much about the minor stuff unless it becomes a pattern or it's interfering with your ability to actually understand the process and ensure your child's getting what they need. But if it's something important, work up the ladder, talk to the individual teacher, talk to the case manager, talk to the IEP team, talk to the special ed coordinator and or the principal, and even go up to the assistant superintendent for special ed or the superintendent. Try to work things out informally as much as you can. Make love, not war. Your child will be much better off if you have a solid, positive, collaborative working relationship with the team and they feel your appreciation and support and your respect, but also they're showing respect and appreciation for you. There are legal remedies available through mediation and due process if you cannot work things out with the school district. but those are frustrating, time-consuming, expensive, and just not a great way to solve problems, particularly the due process hearing. So avoid that as much as possible and try to work things out wherever you can. And if you really hit a deadlock, I'm a strong believer in using mediation to try to work things out. And where we hit roadblocks or dead ends with schools in the IEP process, we have a lot of success getting things worked out in the mediation process. So I would strongly recommend that. All right, so you can reach us. I think in the first slide, I indicated our website, www.mattcohenassociates.com, has lots of resources on it, including over 40 different webinars or PowerPoints that I've presented or other members of my staff have presented over the last few years on special ed topics. And if you need specific consultation, it also provides a way to contact the office for that. So I wish everybody luck. Hope that was helpful, and I'm happy to leave 10 or 15 minutes for questions.
Yeah, let's anybody have any questions? Thank you, Matt. Any questions? That was a lot of information.
I actually have a question here.
Sure.
We're a little bit further along in our process, and we are looking for school placement. And I'm wondering,
You're looking for schools?
Elementary school.
Uh-huh.
So my question for you is,
I don't know if legally you can share this, but is there anywhere that you would suggest we steer clear of, or any districts that you know aren't easy to work with kids that have IEPs?
You know, I don't feel good about answering that question. And apart from it just being a kind of a nasty thing to put out there into the universe, my experience is that board members and principals and administrators change all the time. Somebody's talking who needs to be muted, I think. I don't know who that is, but board members, superintendents, special ed directors, and teaching staff change all the time. And so I've actually had people call me from all over the United States saying, where should I move? And the last thing I want to do is tell you to move somewhere. And then the staff who are the good staff leave, and the parent is suddenly faced with a school staff that's much less friendly to working with parents. And in fairness, the other way can also work. You can be in a school district that's been very difficult to work with, and they end up with new administration, and suddenly it gets much better. And by the way, parents can also influence that process. So if you're in a school district that's having problems, I would encourage the parents to contact other parents, form a parent advisory group or a support group, and go into the administration and say, hey, we've got some concerns, and we feel like there needs to be some action taken, either to change how you're interacting with us or to change the personnel so we get people who are more supportive. But,
And I do have, you can go onto some Facebook pages for the different neighborhoods and look for some parent Facebook pages, and they are very open, and because I see a lot of them and answer some questions. So people have gone on Facebook pages, whether it's Naperville or Park Ridge or whatever location, and have asked, how the school districts are, and people are always willing to help answer questions. So that could be another avenue to be checking out different areas. Anna, she's currently in the process of setting up an IEP for her child. Oh, she just said this is very informative. What's the first step for starting the IEP process in Chicago?
send a note into the principal, or you can even do it with your teacher, but it's better to do it with the principal. Those sorts of communications, it's always wise to keep a copy so that you have documentation that it was submitted. And then the process is that when you submit a request for consideration for special ed, they need to decide whether they think that there is something going on that may warrant special ed. And then they have to convene a meeting to discuss what the evaluation process will be, and they have to ask for your consent in writing to agree to what the evaluation process will be. They then have 60 school days, which sadly schools often take the full 60 school days before they meet with you. And then no later than at the end of those 60 school days, they're supposed to meet with you, discuss their findings, and then determine whether the child is entitled to an IEP. And within 30 days of that determination, they're supposed to actually meet with you and write the IEP. But you have to start out by making the request in writing.
And, just to interject too, what Matt was saying, about keeping all your, all your communications, get a binder, put everything in there so you're not scrambling for any other kind of communications. So this way everything's there with you, whenever you go to your meetings, or just, keep so it's all in one place. So this way you don't lose anything, you don't forget anything that's been, communicated to you through this process. So we have a mom. Hi, Matt, my son is 4 and will be going to pre-K. The team who evaluated my son thinks he does not need speech or OT therapy in school. I have recommendations from outpatient therapists, behavioral and developmental evaluations. Also feel like he needs it at school. School just agreed to give him speech and OT consultations. With teacher only, is there anything I can do to change this? I disagree with the IEP recommendation.
So yes, there are things that you can do to change it. Again, I would always start with informal discussion. I would make sure that you have reports from your various private therapists or clinicians that set out why it's important for your child to have these services at school. You can request a new meeting to consider it. As I mentioned a few minutes ago, I would go up the ladder within the school district to the case manager, the principal, up to the special ed director as needed. And then if you're unable to get it worked out any other way, then you have the right to request mediation or a due process hearing if you need it.
Can I ask a question,
Sure.
Evie? Hi,
Yeah.
hi Matt. My name is Monica. My son is actually going to have an evaluation with CPS to see if he is eligible for an IEP next month. So we're excited and nervous. Right now he's attending Bluebird. We love it. He's thriving. But just because we know eventually we hope that he's going to go into a public school. So we want to see if he is eligible for an IEP. I suspect that he may need it. He has an eye condition that he cannot see from one eye. So I assume that that's going to impact his reading. He may need extended time for, testing. How would I ensure that they, because I know he also needs speech services, so he's definitely going to qualify in that area. But my fear is that they're not
Monica,
going
let me ask you to come to a question, just since we have limited time. I want to give others chances too.
I guess my question is, what if they disregard the vision on how that impedes his education in the IEP?
Well, sadly, all of the issues that relate to a child when there is disagreement come down to whether you can prove the things that you feel need to be done that they're not agreeing to. And so really the answer that I just gave in the prior question, which is get support from the private clinicians, try to communicate with the various members of the team and move up the ladder in terms of the administration. And then if you're still not able to work it out and you feel like the thing that you're seeking is sufficiently important, then you have the right to mediation or due process to try to work it out. But always better to try to work it out informally if you can.
Okay.
But
Thank you.
You need clinical evidence to back you up if they're not willing to take your word for it.
Okay, thank you so much.
Matt, is the IEP specific for a school district? Or if, for example, you have an IEP in Chicago, does that IEP apply to a school in another district or state?
So that's a very important question, and it's a little bit complicated. The answer is yes and no. So let me explain that. Each school district, whether it's within the state or a different state, has the right to conduct its own new evaluations and to write its own IEP. And the reason that they're not automatically obligated to maintain whatever IEP was already in place is that the school district may have different programs, they have different capabilities, may have more or less staff, they may have a different philosophy about how they feel the child should be educated. And so there can be differences of opinion about the child. They may even feel that the prior district has not done a good job of testing the child, and they want to have a different type of approach. However, that's the part that means the IEP doesn't follow. But if the new school district is saying, we don't want to do what the prior school district had done, and the parent requests mediation or a due process before that new program is actually implemented, then there is a special part of the law called the stay put placement provision, which requires the new school district to implement the prior IEP as closely as possible until the dispute over what the new school district is proposing to do is resolved. So in that way, the old IEP does have an effect, because if you can't work it out with the new school, they're supposed to provide a program that's comparable to what the prior school was providing.
Susan has a question. What would you suggest for parents who'd like their child should be reevaluated by their school district prior to the 3-year reevaluation mark? For example, child previously attended district school, but then transitioned to Bluebird or Merlin, but will be discharged before 3-year mark.
Parents or school districts can request an evaluation in a shorter period of time than 3 years. The 3-year time frame is the longest period of time that a child can go without an evaluation. It's not that it's mandatory that it can only be within 3 years. And if there's a legitimate reason for thinking that the child should be evaluated earlier, the parent can make the request. And if the school refuses, then that's also an issue that can be addressed in mediation or due process.
Thank you.
I have a question, if
Sure.
yes. So my son is at Bluebird now and will be transitioning out in the fall and going into CPS for first grade. We have already visited his neighborhood school. And his IEP meeting is this weekend, this Saturday. So we have not had it yet. But we've visited his neighborhood school and we do not feel as if they would be equipped to implement his IEP. What type of conversation should we be having at the IEP meeting to say which school we would like him in? And do we have that ability?
Well, you certainly have the ability to raise the concern. That doesn't mean that they're automatically going to agree with you. And as I wanted to stress over and over again, you can ask for almost anything that you feel is important for your child. But if there's a dispute about what's needed and the school doesn't agree with you, you need to have professional support or at least data to explain why what you're proposing is correct. And for example, I'm not saying that you're doing this, but if you say you don't like a school because other parents have told you that it's not good, but you haven't gone to observe the school, you haven't met the team, you haven't talked to the principal, that's not going to be very persuasive. The school system is not likely to say, oh yeah, sure, we're glad you're paying attention to rumors and so on, and we're going to just let you pick your school. On the other hand, if you have a psychologist or a speech therapist or someone else who's able to say, your child needs X and Y, and this public school doesn't have X and Y, then you've got a pretty good argument that your child needs to be in a different school. And if your child needs, and I saw that somebody asked the question about, they feel your child needs a therapeutic day school without even attending a CPS school. If you can establish criteria for what your child needs that rule out the public school, for example, that your child needs the Wilson reading program, your child needs a program that the social worker is available in the classroom every day, your child needs a very small setting with very little noise. Those sorts of things may be sufficient to either cause the public school to decide, yeah, it's probably not going to work in the public school. We need to okay provision of private
So,
therapeutic school.
so
Or
Matt,
Yep.
do the parents, do they have to take that school recommendation?
well, they
Or
don't
could-
get to choose the public school just because they have one they like and one they don't like. Yes, they have to take it,
Oh.
and then they're able to challenge that decision through mediation or due process if they disagree with it. But parents don't get choice in terms of where the child goes. Even in terms of selective enrollment, you get assigned a school.
Uh-huh, right,
Can I ask a quick question?
sure.
Hey, so our child had an evaluation by an outside, neuropsychological evaluation a few months ago. There were several diagnoses, and when we had our IEP meeting, they were very clear multiple times in the meeting that if it's not impacting him academically, then they do, that he would not necessarily be qualified. The problem is that he is a 3E child, so his IQ scores and all of that were very high, and he's doing great academically. But we have other concerns, and I was just recently reading a friend shared some things with me, kind of explaining how they can't be denied an IEP based on just on the grades, and they also have to look into the overall educational performance and all of that. So is that, can you just explain a little bit to me on that? I mean, can they just deny
Yeah.
them saying they're doing well
Let
academically?
me explain it, but I have a question for you first, because I've been doing this for 40 years and I've never heard the term 3E before. I'm very familiar with 2E, but I've never heard 3E. So just tell me what the
Yeah, so 3E is when they have an additional diagnosis along with that. They called it 3E instead of the two,
Huh, that's interesting.
yeah.
In any event, the short answer is that just because a child is bright or doing well in school academically doesn't mean that they don't qualify for an IEP if their disability is interfering with other parts of their social functioning at school or behavioral functioning or whatever the impact is. I have many students who I represent who, have very high grade point averages, but they're not going to be able to function in college because they can't get out of their bedroom or get, in a new setting, or they can't interact with peers, or they can't organize themselves to put their pants on in the morning. So there are many different things that can qualify as a basis for special ed.
Mhm.
And if your school district is raising question about that, one of the strategies that I like to use is take a look at the state standards, which the state has for all students. And among the state standards are what's called SEL, for social emotional learning standards. And
Okay.
those standards represent what every public school is supposed to provide for every student. And so for a school district to say that in order to qualify, you can only qualify if you have an academic problem is ignoring a pillar of the state standards for what schools are supposed to provide. And so that gives a very easy way to say, hey, you're not looking at the whole picture here, and you need to address the other ways that the child is struggling.
Right. Is that something that can just be found on like the state education website or something?
Absolutely. Absolutely. So the other trick I like to do is many public schools have what's called a school mission statement that's often prominently posted in the school lobby or the principal's office or whatever. You go in and the mission statement says, it's our job to assist all students to be healthy, successful, and independent as possible, and as good citizens as possible.
Right.
Okay, it doesn't just focus on academics, it focuses on the whole child.
Right. Okay, great. Thanks. I
And
appreciate it.
thank you. And one last question. How can you ensure a school is following the IEP?
Stay involved, review your child's quarterly progress reports very carefully, review what's happening when the annual review is happening, go in and observe, ask for periodic meetings, ask the teachers to give you heads up about what's going on. And if you have doubts about what's being done. Then even more observation. You might want to, if you have private professionals working with your child, have them go in and observe, and also keep track of what your child's assignments are and how they're doing. Are they not getting homework when they ought to be? Are they getting homework, and when they do the homework, you can't read it and make sense of it, and it's way below grade level? Alternatively, the child does perfect homework, but they're spending 3 or 4 hours every night working on the homework when it's only supposed to take a half hour. So there are many different indicators that you can use that spell that there's a warning sign that there's trouble with the child or trouble with implementation. I would also, anytime that you hear that there's a substitute teacher or the key teacher is going on leave or there's a lot of turnover, that'd also be a big red flag that things are probably not going to be done the way that they're supposed to be done.
Well, thank you so much, Matt. This has been so great and so informative. Thank you all for joining us, and I will send out a recorded, the recording next week. Oh, there's two. Oh, and everyone's just saying thank you. Thank
All right,
you.
good luck, everybody.
Thank
Hello,
you.
hello, Matt. I'm so sorry. I just joined a couple minutes ago. I had put a message out that I did not agree with the evaluators from CPS who evaluated my son. They felt like he didn't need speech or OT, but we just got another evaluation where he was diagnosed with a regression genetic disorder. And then do I have to reach out to the CPS evaluation team again to I don't know, like try to change the IEP, or do I have to wait till he actually starts pre-K at school?
You can reach out whenever you want to reach out, but it also helps to have a clear basis for why you disagree and clinical information to do it. I did cover that several times in the last hour, and there are resources, as I indicated earlier, on our website. There are a whole lot of PowerPoints that deal with various topics in special ed. There are a whole lot of actual webinars, recorded webinars that I've done in the past, and other resources that could be helpful to parents.
Okay,
Thank you.
thank you so much.
All right, good luck, everybody.
Yes, thank you all for joining us. Thanks, Matt. Have a wonderful evening.
Take care.